Despite settling a legal claim with cybersecurity startup Corellium last week after a protracted court battle over iPhone copyright, Apple restarted its legal campaign against the company on Tuesday. But it'll be going up against one of the more famous lawyers in the world of code copyright, Tom Goldstein, who recently succeeded in having the Supreme Court slap down Oracle claims that Google stole its intellectual property when it developed Android, in a now famous case that lasted more than a decade. Apple's decision to appeal came less than a week after it arrived at a settlement with Corellium, which it had accused of infringing copyright and breaching the Digital Millennium Copyright Act (DMCA) by creating software that can quickly spin up software-only versions of the iPhone. Corellium has denied the allegations, saying its tools are designed to help security researchers find weaknesses in iOS and developers to test their code without having to buy physical iPhones. The pair settled on the DMCA claim, but Apple is now appealing the December ruling that threw out its copyright infringement claims. Apple didn't reveal what issues it had with the judgment and had not provided comment at the time of publication. Goldstein, who also recently helped Qualcomm fight off the Federal Trade Commission's allegations of anti-competitive behavior, tells Forbes he thinks many of the same communities that backed Google in its tussle with Oracle will be supporting Corellium in its fight against Apple. I do think that we'll see a lot of the same players. It's a reprise of the same kind of overarching themes. And a lot of the community that was on the Google side, I think, will be present here too against Apple. The fair use community, the software community. Google's legal team argued it had added code to Android from Oracle-owned Java under fair use, a legal exception that permits use of copyrighted material if it's applied in a limited and transformative way. And, he adds, the Google victory could have ramifications for the Apple v. Corellium case. There's a real overriding sense from the Supreme Court that there really needs to be fair use in computer software. I don't think anybody could doubt that the Google ruling points in our favor. It doesn't resolve the case, but it's a very strong wind at our backs. Asked if he thought the case could go to the Supreme Court, he said he thought it unlikely, but possible. He isn't expecting a judgment on Apple's appeal for another 18 months. The timing of the appeal is particularly interesting, after Apple, in response to criticism over its announcement of iPhone photo scanning for child sexual abuse material (CSAM), said security researchers could look into iOS code to check whether its scanning tool was infringing privacy.